better ask the court, you better get permission.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me.
Today we're talking about Kyle Rittenhouse, easily one of the most fascinating self-defense cases of all time. The lawyering on the defense side is probably some of the best that we've seen for a public trial. The judge in this case was really good. I mean, just for everything that he dealt with and all of the media coverage and everything like that. Prosecutor in this case had a really, really tough job. No doubt about it, really tough job. He did some things in this case that I'm interested to take a look at. I know this is a pretty polarizing case, but I want to at least talk about some of the things that I think went on in this trial that were really, really good.
Ask the court to strongly admonish him, and the next time...
He's saying admonish, reprimand him, tell him that's not okay. He should never do it again. The gentleman talking here, and that's the lead defense attorney, the bald guy with his arms crossed. He's also part of it.
If it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
So what the defense attorney in this case is asking the court is admonish the prosecutor for what we're about to find out the prosecutor has done. And if it happens again, then the case should be thrown out, right? A mistrial with prejudice, meaning the state cannot file it again. So in a normal mistrial, the state would be able to bring the charges again, retry the case. In this instance, the defense attorney is asking that if it happens again, that the court not allow the state to get a second bite at the apple.
Mr. Finger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
Yikes. Court left the door open. I think we're about to figure out what the court's position is and if they left the door open.
Me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted.
So what the judge saying, reconsideration, if a motion's filed, motion limine, some issue, the court may not dismiss it with prejudice. The court may reserve it, and that's what he's saying he did here. He reconsidered the motion the state had presented, and he accepted it later on.
Motion for reconsideration.
That was not a motion.
Excuse me. I did. I granted.
We did not move
that
to reconsider.
That was their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But
I guess he denied it.
I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury?
So in most of these cases, the probative value versus the prejudicial value of a topic, right? Say the defendant had a criminal record, right? And it was permitted by the rules. The court's going to weigh the probative evidence, meaning how much does it lend to the case versus how much does it prejudice one of the parties versus the other.
You are already,
for example,
I was astonished when you began your examination by commenting on the defendant's post-arrest silence.
Well, I guess we know why defense counsel's asked court to admonish the prosecutor.
That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that.
I think what the judge was getting at there is that based off of that line of questioning, it gives the defendant an opportunity to appeal the verdict. The judge seemed like he wanted to tell the court something, but did not.
So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. Yeah, that's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this.
There's no way you get to the level of the prosecutor in this case without being a great trial attorney. I mean, obviously he has a serious trial record, assuming that it's an elected position if he is the, prosecutor for Wisconsin or whatever district this is in Wisconsin.
This case, the testimony in this case that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed.
Oh man, look at the defense table right now. These guys are about to explode, and rightfully so. I think the prosecutor's missing the point here and possibly mischaracterized the defendant's testimony.
The gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing.
Ugh, the judge remembers the testimony verbatim, it sounds like. I don't know where this is going.
May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory is.
Oh man, he is the smartest guy in the room, huh?
The case is, I want.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please.
I apologize.
The court reporter's over in the corner, I'm sure. We can't see her. Well, maybe she's out front of the judge here, trying to keep up with the testimony as fast as she can, and she actually just asked for the prosecutor to slow down so that she could keep up. The prosecutor's obviously not making too many friends in this courtroom, and now he's talking to the point where he can't get the court reporter to keep up.
Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting, with the defendant, to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling, because I thought your ruling was if the evidence in this case made that more relevant, you would admit it or at least consider it an admittance. I believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements to, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
So he keeps saying impeaching. Impeaching is just trying to think of the defendant made a statement, and now through some record or some evidence or some testimony, the prosecutor's trying to impeach the testimony, saying that, look, the defendant's statements are inconsistent. His testimony is inconsistent. It's not adding up. I think what the judge is getting upset about is it's not his statements that the prosecutor's talking about. It's his belief system that he would defend property with this AR-15.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you...
So we talked about that earlier. Pretrial order, right? This witness that the state had some sort of prior conviction, and if he didn't, again, I don't know. I'm just assuming based on what the defense attorney is saying that was a point of contention because there was some sort of pretrial order saying you can't talk about that. The defense attorney here is saying that he talked about the pretrial order with someone from the prosecutor's side, that the testimony going down that road stopped.
You better ask the court, you better get permission. This is ridiculous.
Again, you got to ask the court, because if you don't ask the court, that statement, that line of questioning, if it's not permissible by law, it could unfairly prejudice the defendant, right? In this case, Kyle Rittenhouse.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other...
All right, so I was wrong. His belief system isn't that he defends property with an AR-15. The state is trying to say that his attitude is he wants to shoot people.
Trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me.
Oh, man. Judge is starting to get pretty heated now. And I think Kyle Rittenhouse's attorneys they got to be some of the best that I've ever seen. I mean, I was glued to this trial. They had the toughest job, and they did an absolute phenomenal job.
You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters. And the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time.
Lying in wait is one of those that would carry first-degree murder or something similar, that it wasn't a coincidence, it's premeditated, right? Lying in wait. He was going there. He had this premeditated thought of what he was doing. And as we know from seeing the footage in Kyle Rittenhouse's trial, he's getting attacked, right? Kyle Rittenhouse is getting hit in the head with a skateboard. I mean, that's not premeditated, right?
Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities, Wigmore and evidence, Judge Weinstein, Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions.
What the judge just did there is he broke down in a really great way. I mean, he's doing a heck of a job here. The judge said, here's what the law is. The law says this, that you've got to have these things. And you're trying to compare this prior shoplifter event to an instantaneous shooting event. Or at least that's
whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in. No matter what you think.
Wow.
Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have.
So I guess we figured out what the defense attorney in the first part of the video was asking the court to admonish the prosecutor about. The prosecutor must have addressed the defendant's silence at some point. Now, as most of you know, every defendant in every criminal case has a right to remain silent. Same reason you have the right to bear arms, same reason you don't have to quarter the Brits, right? You don't have to be subject to unlawful search and seizure under the Fourth, right? Your right to a jury trial, your right to counsel. All of these things are fundamental to our lives as Americans. What the judge is talking about is that the prosecutor is so seasoned that he knows that he's not allowed to talk about how the defendant is silent because silence implies guilt, and the jury isn't going to know any better.
I have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
That is probably one of the more interesting ones. The other one I want to talk about, and I haven't seen, is the prosecutor holding the AR. That's also a pretty interesting one, so we'll see if we can track that one down. If you have any good video content or any legal thoughts or any other videos you want us to comment on, if you have any other videos that you want me to comment on, please let us know down below. Like, subscribe.